Let's get to the story of the day. Kari Lake lost most of her appeal. If you read any of the news, you would think that she lost most of her appeal. And in a technical sense, you'd be right, but you'd be misinformed and misled. I put together a bit of a montage here. By the way, just so everybody knows, after this, I'm going to go exclusive to locals and then respond to the tips in locals and the comments there, and have a locals exclusive where everybody can feel free to sign up, join in, and whatever. Here, this was the montage. I took 5 seconds, but if you just put it in, Kari Lake appeal, what would you see? Look at this. Los Angeles Times. Arizona court declines most of Kari Lake's appeal over her loss in governor's race, yada, yada. Yeah. Washington Examiner. Arizona Supreme Court rejects majority of Kari Lake's governor race appeal. Arizona Central. Kari Lake election challenge mostly rejected by Arizona Supreme. Mostly. It's not totally dead. It's only mostly dead. And then if you read a little further into the Los Angeles Times article, in an order Wednesday, the state's highest court said a lower court erroneously dismissed Lake's claim challenging the application of signature verification procedures on early ballots in Maricopa County. Why, that actually sounds like a very material aspect of the appeal that succeeded. The court sent the claim back to trial to consider. But she lost most of it. Here, let's pull up another article. Let's pull up the New York Times. Bastions of truth and accuracy. Still have up on the internet Brian Sicknick murdered by a group of Trump supporters. Still have that up on the internet. Never formally corrected, retracted, apologized for that. The New York Times. Arizona Supreme Court turns down Kari Lake's appeal in her election lawsuit. Can you believe that this is the headline? They didn't even go with mostly. Might have to read the next line to, hold on, got a dog dragging her paralyzed privates. Oh, shicer. Okay, that's what I wanted to avoid. Get, come on. Right. Just dropped a flipping hard drive on the ground. Yeah, Pudge scoots her butt along the floor, and private parts end up getting snagged in cables and pulling computers off tables. The New York Times doesn't even put in the word mostly in their headline. Arizona Supreme Court turns down Kari Lake's appeal in her election lawsuit. I mean, I feel like I'm taking crazy pills. This actually feels like it has to be wrong. This feels like it has to be a bogus headline. They don't even put in mostly. The justices refused to hear Mrs. Lake's claims disputing her loss in the governor's race, but sent one part of her lawsuit back to a trial court. I'm sorry. So then your headline is a lie, New York Times. Your headline is a bloody lie. Turns down Kari Election's appeal in election, but it sent one part of it back for trial, for review. Oh, so you're liars. Arizona Supreme Court on Wednesday denied a request from Kari Lake to hear her lawsuit disputing her loss last year in the governor's race. The lawsuit was based on what the court said was a false claim by Ms. Lake, a Republican, that more than 35,000 unaccounted ballots were accepted. We're going to get into this statement, by the way, because this is where the court, as you'll read from some people's tweets, reserved the right to seek sanctions for this allegedly false claim. In a 5-page order written by Chief Justice Robert Brutinel, the court determined that a vast majority of Ms. Lake's legal claims, which had earlier been dismissed by lower courts, lacked merit. The vast majority. We're 2 paragraphs in, and they're finally attenuating their headline lie. The Court of Appeals aptly resolves these issues, Chief Justice Brutinel wrote, adding that the petitioner's challenges on these grounds are insufficient to warrant the requested relief under Arizona or federal law. Fine. But the justices on Wednesday ordered a trial court in Arizona's most populous county, Maricopa, to conduct an additional review of that county's procedures for verifying signatures on mail-in ballots, keeping one part of her lawsuit alive. I'm sorry, you said they rejected it. They turned it down and yet kept it alive? The decision dealt another setback to Ms. Lake, a former television news anchor whose strident election denialism helped her to gain the endorsement of former President Donald Trump. Ms. Lake tried to put a positive spin on the ruling. Accuse your enemies of doing what you are doing so as to create confusion. Hashtag confession through projection. Get your own shirt at vivafrei.com. Contending that Twitter, that remanding the signature verification aspect of her case back to the trial was vindication. It was. And it's probably the most material element, the most material claim of her appeal. But it's not the New York Times that's trying to put a negative spin on this, or a spin that makes Kari Lake look like a loser. It's Kari Lake who's trying to put a positive spin on the fact that they are going to address signature verification in Maricopa County, at the very least on early voting ballots. Ms. Lake had argued that a material number of ballots with unmatched signatures were accepted in Maricopa County. The Supreme Court agreed with the appeals court ruling on the matter, effectively saying that she would have to show the number that proved the election outcome would plausibly have been different, not simply an unearthed assertion of uncertainty. She fell to Katie Hobbs, a Democrat, by 17,000 votes, yada, yada, yada. Representatives Ms. Hobbs, they did not immediately respond to requests. Who cares? Okay. Liars. Just bloody liars is what they are. And don't worry, people. We're not just going to rely on the New York Times or my word here. Here's a link to the article. Let's just go look at the order. It's not very long, but there's two elements that I want to look at. I was going to do a car vlog on this, but Viva Frei might turn into Jablinski Games for the next vlog. Like, oh, we're gonna do the vlog. We're gonna do it. Jablinski Games, for anybody who doesn't know. How do I get there? We go. Okay, so I think that's. Can I zoom in on this? Robert Gouveia is live in 30 minutes. Okay, I don't think I can zoom in any more than this. We see this? Okay, good. Let's just go down here on December 24th. This is the order filed, yesterday, March 22nd. Plaintiff Kari Lake, Katie Hobbs, honorable. It's an en banc ruling, I think. The judge, Peter Thompson, in and for the state of Maricopa, the respondent. Oh no, that was against the parties. That doesn't matter anyhow. I thought it was an en banc ruling. Let me just see something here. Who cares? Okay, it doesn't matter. Let's just go read through this and stop scrolling to make everyone nauseous. On December 24, 2022, the trial court issued its advisement ruling rejecting Petitioner Lake's challenge and confirming the election of Katie Hobbs as Arizona governor-elect pursuant to yada, yada, yada. The Court of Appeals affirmed in an opinion issued February 16, 2023. Petitioner Lake filed her petition for review and request for expedited consideration on March 1. Oh, yeah. Okay. The court en banc, meaning on the bench. We've talked about this. En banc is like a panel of the judges of the Court of Appeal. Granted petitioner's motion for expedited consideration of her petition for review. Okay. The court has considered Petitioner Lake's petition for review and responses filed by the governor, Katie Hobbs, yada, 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 Maricopa County. The court has also considered the record, the trial court ruling, and the Court of Appeals opinion affirming the trial court. The court has also considered briefing. Okay, fine. Amici from whom? Okay. So they deny it 1 through 5 and 7, but leave 6. The Court of Appeals aptly resolves these issues, most of which were the subject of evidentiary proceedings. So everybody knows, like, this is under Quebec law. I think it's pretty much the same under all appellate review, but the level of deference that the Court of Appeal gives to the lower courts when it comes to appreciation of the evidence is greater than when it comes to questions of pure law. So the Court of Appeal will intervene on matters of law almost as a rule, but will be much more reluctant to override the trial judge's appreciation of the evidence, which they say the trial judge is uniquely or singularly in a position to better appreciate than an appellate court, which doesn't actually hear witnesses or doesn't hear witnesses or assess evidence. Okay. It is ordered denying review of the issues 1 through 5. We already did that. Okay. It is further ordered granting review of issue number 6 to the extent count 3 of the complaint challenges the Maricopa County recorder's application of signature verification policies during the election. Issue number 6 asks, did the panel err in dismissing the signature verification claim on latches, mischaracterizing Lake's claim as a challenge to existing signature verification policies when Lake in fact challenged that Maricopa County or Maricopa failed to follow these policies during the 2022 general election? In count 3 of her complaint, which alleged a violation of the Arizona rules of whatever it is statute. Petitioner alleged in paragraph 151, upon information and belief, a material number of early ballots cast in the November 8, 2022 general election were transmitted in envelopes containing an affidavit signature that the Maricopa County Recorder or his designee determined did not match the signature in the putative voters registration record. That's not a small thing. The Maricopa County Recorder nevertheless accepted material number of these early ballots for processing and tabulation. Contrary to the ruling of the trial court and the Court of Appeals opinion, this signature verification challenge is to the application of the policies, not to the policies themselves. Therefore, it was erroneous to dismiss this claim under the doctrine of laches because Lake could not have brought this challenge before the election. Can you imagine the lower court and then the lower court or the Court of Appeal dismissed it on laches, said that she took too long to contest this aspect of the election, which didn't occur until the election itself? Sorry, laches. We're going to have to put you up in the pantry and lock you up behind some latches. Oh, for God's sake, that's terrible. So no. Yeah, technically 5 out of the 6 claims were dismissed. The one perhaps most material aspect of the appeal was allowed, the judge concluding that you can't bar Lake from appealing that on laches when the cause of action only arose when they apparently did not properly match signature verifications on the early voting with the voter record. Holy sweet merciful goodness. Oh no, but Kari Lake is spinning this as a victory. Then you're going to hear some people citing this. Her appeal was so dismissed, according to the New York Times, even though it succeeded on one element, that the judge reserved the right for sanctions. Listen to this. It's further ordered petitioners may file a response and respondents may file a reply to respondents' motion for sanctions in accordance with RCAP rule, whatever, I don't know what that is. The parties shall address as a basis for sanctions only petitioners' factual claims in her petition for review, i.e. that the Court of Appeals should have considered the undisputed fact that 35,563 unaccounted for ballots were added to the total of the ballots at a third-party processing facility, and not legal arguments. So the sanctions is only going to pertain to statements of fact that the court has now determined to be factually unsupported by the evidence. The sanction will only apply to petitioners' factual claims. I'll just say that. So the motion for sanctions will not rely on arguments of law, but rather only on statements of fact that were subsequently disproven. If sanctions, here's my bold prediction as a lowly Canadian dumbass with nothing but a Quebec law degree. There will be no sanctions awarded in this case, period. You cannot, in my humble view, dare entertain the idea of awarding sanctions when the appeal has been successful, if only in part. That's my humble view. And the idea of parsing out sanctions to sanction certain statements that were not sufficiently proven in court, despite the fact that an element of the appeal was successfully argued and granted, would be an absolute weaponization and bastardization of the sanctions process itself, based on my understanding of how sanctions are applied in Quebec. In Quebec, just so you should know, to get sanctions, like in my view, they're handed out like Halloween candy in the United States. To get sanctions in Quebec, you have to prove a patent manifest abuse of the judicial process, malice in the filing of the lawsuit, malice in the conduct of the lawsuit, not having made certain statements of evidence that were ultimately not panned out or retained by the court. So I'm predicting that there will be no sanctions in this court, but with the caveat, if sanctions are awarded, it would be the most absolute politically motivated bastardization of the sanctions process. There, I said it. Now, just imagine what your understanding of the Kari Lake decision is. Based on what we've now gone over together, based on the actual court filing, as opposed to the bullshit headlines in mainstream media and the absolute misinformation, disinformation reporting from the old gray lady, the New York Times. It's night and day. Let me just see if there's anything else I missed about Kari Lake. I mean, we can go to some of the tweets, but hey, just know when you see some of these tweets, oh, it was such a frivolous appeal that was granted in part that the court reserved the right for sanctions on only some of the claims. You're being misled, you're being duped, and there are going to be a great many people out there who are not going to understand that not only did Kari Lake not lose on her appeal, she actually succeeded, albeit on one of the claims, but albeit, I would argue, the most important aspect of her appeal. And my goodness, the fury that you are going to hear if the signature matches don't match. Someone just said, minimum underdrive says, New York Times subscribers don't get past the headlines. No question about that. VivaBarnesLaw.locals.com members are slightly above average and get past the headlines. Yeah, I don't think there's anything more on Kari Lake. Good on her. Oh, no, except for the media demonizing her, an election denier. My goodness, is she tenacious? I think she's charismatic. I know that she was a reporter, so that might explain some of the reflexive charisma. I like Kari Lake, and I won't apologize for it, period.